Thank you for joining us once again on the State of Freedom.
The State of Freedom is a listener-supported podcast. We are committed to pursuing the truth about policymaking, regulatory actions, and political maneuvers in Louisiana and at the national level that stand to impact your freedoms.
Please support the State of Freedom by becoming a monthly supporter or member of the Warrior Circle, or by advertising your business, your nonprofit, or your event with us. Go to freedomstate.us. We are bypassing the mainstream media cartel and the establishment political parties in Louisiana and coming directly to you, spreading the uncensored voice of freedom across Louisiana and beyond. Red Zeppelin is the best kept secret, but because of us, it's really not a secret anymore. Anybody who has not been to Red Zeppelin on Perkins Road in Baton Rouge, you're truly missing out. The best environment, the best service, and the best pizza in the state of Louisiana. Go to Red Zeppelin today. Tell them the State of Freedom sent you.
Good morning, everybody. Sorry about that. Struggle busing, but we're going to make it.
Not to be confused with party busing, which is absolutely not the case this morning.
That's right. Sometimes the struggle bus comes after the party bus, but that's also not the case today.
Not in this
unless,
case.
Unless you call looking at 300 pieces of legislation a party, which some people might.
There was a bus, but just not a party bus.
Welcome to the State of Freedom, everybody, where we are grounded in faith and the Constitution, where we're committed to giving voice to the truth, living with courage, and taking action. It's Thursday, April 9th. It's 8 a.m. Central. We're clinging to our coffee cups, white-knuckling it. I'm Danielle Walker, and I'm joined by my good friend and co-host, the watchdog in chief of Louisiana Citizen Advocacy Group, Chris Alexander. Good morning, Chris.
Good morning, Danielle. How are you doing?
I'm good. I'm here.
A little delirious.
That's excellent. Yeah.
But trudging right through.
We are. And we're coming to you live on Voice of the People USA TV and radio network on Rumble, X, YouTube, and Facebook. I'm seeing the Rumble looking like it might not have come in. I'm not sure if the Rumble feed's working. Maybe Katie or Monica can tell us if it is working. But wherever you're watching, please take a moment to hit the thumbs up button. Share this with your friends. You can also catch us later on our audio-only podcast platforms like Spotify and Apple Podcast. And we have so much to discuss with you this morning. We've got a lot of really great reports, and truly, there's something for everybody this morning. If you care about anything, it's probably in the lineup today. And we are excited to be having a good report. Sometimes it feels like a good report is an anomaly, but anyway.
Sometimes it feels like a good report is when when you're really leveraging up against the door to keep the waves out from just completely drowning you. On some days those are victories, and on some days victories come a lot more overwhelmingly to us than that. We've had some good victories lately.
Yeah, we have. Walter, I see that you're in the Rumble chat. Would you mind just letting us know if you're watching us live or if it's stuck? I don't know if the feed's working. Hopefully he hears that and is able to. Well, let me read the scripture of the day because we got a lot of ground to cover this morning.
Yeah, let's do it.
Titus chapter 2, verse 14. It says, "He sacrificed himself for us that he might purchase our freedom from every lawless deed and to purify for himself a people who are his very own, passionate to do what is beautiful in his eyes." And I was reading that this morning and just thinking, our sin doesn't just separate us from God, which we know that it does, but it weighs us down and it becomes a prison that we don't have the ability to break free from in our own strength. And if we go on long enough like that, we allow that to become part of our identity and part of the way that we behave generally. But Jesus sacrificed himself for us so that we can be absolutely free, no longer having to live with that inescapable feeling of unending heaviness, and walking in true freedom. And if you have ever had that moment, that decision point in your life where you have chosen to accept Jesus, you know that the heaviness before it and the lightness beyond it are unmistakable, absolutely unmistakable. And in Luke chapter 4, verse 4, sorry, y'all, look, we're going to get there. In Luke chapter 4, it's where Jesus is reading the scroll of Isaiah, and he's in the temple, and he proclaims this: "The Spirit of the Lord is upon me, and he's anointed me to be hope for the poor, healing for the brokenhearted, and new eyes for the blind, and to preach to prisoners, you are set free. I've come to share the message of the Jubilee for the time of God's great acceptance has begun." And that's what he's paid for. And that's what he wants for us. It's to be free and to freely choose to love him, to freely receive his acceptance, to follow in his ways, and to be beautiful, passionate reflections of his worthiness. So I just encourage you this morning, if you are feeling weighed down, take it to Jesus. If you are feeling like you are stuck and can't move forward, take it to Jesus. He wants to set you free from whatever it is that's holding you back.
Yeah. And remember 70 times 7. If we're supposed to forgive each other 70 times 7 times, imagine if someone offended you in the same way, Danielle, 490 times. Is that what that comes out to? I'm not good in math. And we're supposed to forgive that many times. Imagine the exponential nature of God's forgiveness and God's mercy and God's love. I just think that what keeps people from God and keeps people from the heart of Christ more than anything else is their own false belief, and I do believe that it's satanic. I do believe it's from the devil, that they cannot be forgiven. They cannot be reconciled to the Father through Christ. Maybe for others, but not for me. I'm beyond redemption. And I think the consistent message that you've given and that I've given is that nobody is beyond redemption. And there's extraordinary freedom that comes in knowing Jesus and knowing his towering mercy. And that's what I think we need to always remember. And I would simply say that, I know that maybe you have a disagreement with this, and I don't, and maybe it's not even fully scriptural, although I think it is. If you look at St. Paul, that nothing can separate us from the love of God. Nothing can separate us from his love. So I think that people need to understand that while sin is damaging and it does rupture the relationship, there is nothing that can sever God's love for us. And he will always be there for us in his mercy if we turn to him, no matter what. And so sometimes people can be so filled with shame when they commit serious sin or do really bad things that they believe that their relationship with God is permanently ruptured. And we have to remind people that it's not.
That's right. Yeah, and Chris, one thing that really has helped me is I heard someone say along the way, this is years ago, that it's arrogance to believe that your sin is so bad that God's death, Jesus's death and resurrection wasn't enough to cover it. It's absolute arrogance to think that you have the right to be unforgiving towards yourself whenever he has said he's forgiven you. And I just think it's a good reality check, right? Like that's not humility, it's arrogance. And we have to put that aside to accept what Jesus has done.
So interesting, Danielle, that pride on some level would be the root of even sort of the type of self-loathing and self-pitying that we believe permanently separates us from God. The root of even that could be pride and arrogance. That's what an interesting observation.
Yeah, it is. And I, like I said, it really has helped me to kind of be able to shake free of that unforgiveness of self, right? And to move forward and say, all right, if he can do it, I can do it. And that,
Absolutely. Well, I forgive you for making me go over 26 bills that we have to talk about today. I forgive you.
Jeez.
I just want you to know. See, we're leading by example.
We are, yeah. It's mutual forgiveness here because neither one of us really look. But actually, the thing is, we say this is a lot of bills, but there were so many things that I think we have felt are really important to cover, and just examples of what the legislature is up to. So, good, bad, and ugly,
Oh,
and that's
absolutely.
what we always are committed to bringing: the good, the bad, and the ugly. And
The
so,
good, the
why
bad,
don't
and
we
the
kick it off, Chris?
yeah.
With some things that happened on Tuesday in House Ways and Means. I know you joined me in this. I was very concerned about this bill being brought by Representative Denise Marcel, her House Bill 515, because it was going to authorize the local government to sell adjudicated property. So that's property that what has a lien on it, or anyway has not paid its taxes or something like that. Probably it's probably run down. It might be a blighted property that's been gone uncared for or whatever.
Right.
And she had a provision that was going to make it possible for local governments to sell that directly to a buyer. And we just had a problem with that because that is just an on ramp for corruption right there. The current law, as you explained it to me, Chris, is that there must be an auction, and
Yeah, Mindy.
everybody in the community has the opportunity to raise their hand and purchase it if they want. But if the person who has the owner of the adjacent property gets first right of refusal as a direct purchase, and I think that's more than fair. So you went and testified on this bill. How did it shake out?
It shook out very well, and your concern is very well founded, Danielle. That under this bill as originally written, it would allow local governments to once they have gained control of property that's valued at $50,000 or less, and and they assume control of it if the property taxes haven't been paid, or for whatever reason the original owner has forfeited their ownership of the property. It is reclaimed by the government, and under this bill, it would have allowed the local governments to sell the property without any kind of public bid.
Yeah.
Basically sell it to whomever they want. I do believe that there would have been an established appraised value. So that wasn't the real concern. The concern was them being able to pick and choose
Yeah.
with no competitive bidding and no public auction who this property was sold to. And as you said in the very beginning, it was an absolute recipe for corruption. But the bill, we opposed it in its original form. It's now been amended to require a public auction where all interested parties can bid on the property, make an offer, and only once it goes through a full public bid, if it still hasn't sold, and that obviously would be a case of just, but 9 times out of 10, it's going to sell because a lot of people buy this property, flip it, turn around, and make money off of it. So it's usually going to sell. But if it doesn't at that point, then the local government could sell it, but it would still have a required appraised value. They couldn't just sell it for very cheap. So there are protections now in the bill that were not in there originally.
Yeah, and it passed unanimously as amended. And I also just want to mention one other thing, Chris. I have heard some hair-raising stories about parish leadership in certain parishes using their influence to direct the purchase of certain properties, private properties, to companies of any kind. And so if influence is being exerted in that arena using private property, imagine what would be done if there wasn't even the need to own any property to start.
Oh,
I'll just leave
yes.
that right there.
And I just applaud you, Danielle, for bringing my attention to this bill originally. And I'm just very happy that it's now been amended to provide for real transparency and for real competitive bidding on this property. And it's just not completely in the hands of a local government doing with it whatever they choose to do.
Yeah. I mean, look, we want to trust our local government leaders, but we need to also put protections in place so that we're not taken advantage of.
Exactly.
All right, next up, House Bill 485 by Representative Beryl Amedee. This is her constitutional amendment for parental rights. And it was supposed to be heard on Tuesday, but it was voluntarily deferred again. Chris, you got some details on that.
Voluntarily deferred for the second time. And, you know, I don't really know why for sure, but, you know, I think it has something to do with the fact that if this were to, well, first of all, let me just say what it is for people who didn't listen to the last show.
Sure.
This is a constitutional amendment that would just put into our Constitution an amendment that says that parents have primary authority over their own children. Most people would say, well, that's pretty much common sense. But in light of the society in which we live now, with a government that increasingly seems to be encroaching into the relationship of parents and their children, we
Yeah.
need this. We have to have it. And it would simply say that parents have primary and principal authority over their children. And if the government wants to get involved in that relationship in any way or assume authority over a minor, they have to show a compelling government interest in doing so. And they have to show that their means by which they achieve that interest is very narrowly tailored to infringe upon parental rights as
Yeah.
minimally as possible. So that's all it does. And you would think that this would be non-controversial, particularly in light of recent history. But it hasn't been. There's been some significant pushback on this bill. And I think Representative Amedee at this point is trying to posture it in such a way that it can get through the committee and onto the floor and passed. We support this, I mean, enthusiastically. And as I said a minute ago, it's hard to imagine how anyone could have real problems with this. I just
Yeah.
don't quite understand that.
Yeah, we've heard some rumblings, Chris, that it may conflict with existing statutes and could lead to potential lawsuits. I mean, so could any other bill, really. So I kind of feel like that's part of the deal. Whenever you pass a law, there's a chance that somebody's not going to agree with it or want to challenge it, and that's why they have courts. But anyway,
They're not going to, the
we'll
challenge,
keep an eye on
Danielle,
this one.
yes, but I have to say this. Any challenge to this would not be successful because it's already Louisiana Supreme Court precedent. It's
Yeah,
already the law under the Louisiana Supreme Court. All this does is prevent a future Supreme Court or a future court 10, 15, 20 years down the line from coming in and reversing that precedent with five out of nine Louisiana Supreme Court justices. And that's all it would take. But if it's codified in the Constitution, it's much more difficult to amend it or to reverse it. That's why it is an important and needed layer of protection over the parental child relationship and the primacy of parents over their children. It's extraordinarily important, this amendment.
yeah, it's extraordinarily important. We're definitely going to keep an eye on this one. And my concern, or when my alarms start going off, is when people start protesting legislation that makes absolutely perfect sense, and is not, there. Look, is Representative Amedee trying to hide something or do something different with this bill than what it absolutely says on its face? No, and that's obvious. She just wants to protect the parental authority in the parent-child relationship. So I have a
Ex-
real problem when someone's going to stand up here and start complaining or challenging it or hemming and hawing about why we don't need this. If we don't need it, if there's no need for it, then why do you have such a problem with passing it?
In other words, if it's innocuous,
Yeah,
why are you taking your time to come down to the legislature and testify against it? You know what the
exactly.
main opposition to this was? It all centers on one thing, that this constitutional amendment will curtail the right of the government to uh, to take legitimate action when it's necessary to do so, like in situations of emergency and that sort of thing. My response is that is exactly what strict scrutiny under the Constitution is. The
Yeah.
government has the right to take action under emergency situations. That is a compelling government interest as long as the means by which that goal is achieved is narrowly tailored. That is already addressed in the amendment itself. So that's a
Yeah.
bogus, specious objection. It really is. I really believe that they do not want the fundamental primacy of parental authority to be codified in our Constitution. I don't believe they want that because I believe that part of their design on restructuring our society is having that avenue for government control over our
Yeah.
children, the
Yeah.
nanny state.
Yeah.
That's why they're opposing this.
Yeah, absolutely. And we have another bill to talk about a little bit later that gets into the nanny state that that we haven't mentioned yet, I don't think. Excuse me. But let's move on, Chris. We'll talk about House Bill 51 by Representative Debbie Villio, her constitutional amendment that would restrict post-conviction bail for child abusers. We enthusiastically supported this one. I think the monsters need to stay locked up and don't need to be able to roam free before they go away for longer.
Very well said, Danielle. Very well said. This is post conviction. They have been duly tried and duly convicted by proof beyond reasonable evidence. So at that point, they're convicted felons, not just convicted felons, but they're guilty of very serious crimes against children. And as a matter of public policy, Debbie Villio's bill basically says that once that has occurred and you've been duly convicted, you're not entitled to post conviction bond, period. And we believe that's appropriate because they have been duly adjudicated guilty. Due process has been honored, and I think it's a good bill. It protects society, and because, Danielle, let's just be honest, a lot of these predators, they don't have the capacity not to continue to offend. And when you're having someone out on the street with post conviction bond, and some of these judges, believe me, would give it to them if they were allowed to do so. I just believe that we do not need that kind of vulnerability, and our kids need to be much better protected than that. It's a good bill.
Yeah, it is a good bill. Okay, next up, House Bill 526. Oh, and maybe I'll just interrupt myself to say it looks like the Rumble feed finally picked up. Katie said it was about 8 minutes of waiting before it picked up. So I'm not sure what the delay was there, but thanks to everybody who was persevering with us. We hope you can see us now. If not, well, I guess they can't hear me to say refresh, but
Well,
okay.
welcome aboard. Welcome aboard, Rumble family.
Yeah. Next up, House Bill 526 by Representative Kelly Dickerson, and this was her bill to limit claims for general damages. You have basically a longstanding, strongly felt belief that general damage claims should not be limited by the legislature in any way, shape, or form.
No, not unless the committee that was going to make this decision goes and sits in a jury box and listens to every bit of evidence that's presented in a case, and therefore they are in a position to make an informed judgment on the appropriate amount of damages to be awarded in a given case. I think that it is just, it boggles the mind to me how the legislature believes that it is in a position to determine what is fair, what is just, what is equitable in a given case. And
Yeah.
some of these cases involve catastrophic injuries, and only a jury and only a judge are in a position to adequately quantify what those damages are. I know that there are some exceptions in the bill that either raise the cap or I mean, significantly raise the cap. But as a matter of principle, I do not believe in statutory damage caps. And I believe that we're on the right side of this issue, both legally and practically. One of the opposition witnesses to this bill, Danielle, testified, and this was compelling to me. He said that, we've had medical malpractice damage caps in Louisiana now for many, many years. In other words, if you're suing a doctor for
Yeah.
medical malpractice, I believe it's a $500,000 general damage cap. And do you know that we rank number 8 in the country, I believe he said, in medical malpractice premiums that doctors have to pay? So they have a strict statutory damage cap, yet they're number 8 in the premiums that they have to pay for medical malpractice insurance. I think that that is certainly compelling evidence that caps really do not work.
Yeah.
And I understand
Well,
the concern. I understand that they have nuclear runaway jury verdicts, but that's exactly why there's a built-in statutory mechanism to address that within the judicial system itself. The trial court is able to reduce a judgment if it's manifestly erroneous or just an abuse of discretion. The appeals court and ultimately, the circuit court, and then ultimately the Louisiana Supreme Court can look at it de novo, what's called de novo, and reduce a verdict as well. There are multiple ways to do so within that system. The legislature does not need to be setting arbitrary damage caps when it's not in a position to do so.
yeah. And the positive news is it failed in committee, so we don't have to worry about that one.
It failed in committee by one vote.
Yeah, 4 to
but
5.
but nonetheless, look, and I understand that what the intent behind the bill is, but it's not the right approach.
Yeah. Okay, next up, House Bill 192 and House Bill 37 by Representative Chuck Owen. 192 is his constitutional amendment that prohibits the expropriation of property in Louisiana by foreign adversaries, and House Bill 37 was a little broader than that. And the constitutional amendment passed 8-0. It's like
Yeah,
this, I do feel like this legislature has had a little bit of a lobotomy when it comes to dealing with foreign adversaries. It's like all of a sudden they realize like, oh wow, they're not just like cartoon characters that are made up. They're really in our communities.
absolutely. And in 192 is the one that prohibits any foreign adversary or agent of a foreign adversary from expropriating any property in the state of Louisiana, right? And that's a
Yeah.
constitutional amendment that'll go to the people. And then I think it was the one with the HB 37, I believe, Danielle, is the one that was much broader,
Yeah.
that says that no foreign government, whether they're an ally or an adversary, can expropriate. And that one was voluntarily deferred. But I think maybe it was HB 80, or there was another one that Chuck had that goes along with his constitutional amendment that simply defines what a foreign adversary is. So if this constitutional amendment passes, banning foreign adversaries or agents of foreign adversaries from expropriating property in our state, that statute would be enacted defining what a foreign adversary is and what an agent of a foreign adversary is. So it's just the companion statutory legislation, but we need this. This is absolutely common sense. You don't think the people in Louisiana, if faced with that question on a ballot, are going to 9.9 out of 10, not that we believe in fractional voting, are going to support that constitutional amendment? Of course they are.
Well, we believe fractional voting exists. But Chris, let me ask you this. So you said that that he has a bill that's defining a foreign adversary. We know that's been defined in previous legislation from years past, from Senator Hodges, probably Representative Eccles' bill. Would this beef up that definition that they used in their bills?
He has the list on the State Department list, the 6 or the 7
Okay, so it's
nations.
the same list.
Yeah, and
Okay.
then right, but he just wanted to have it, clearly defined,
Okay.
and that's what it is.
All right, cool. Next is House Bill 393 by Representative Brian Fontenot. That's Debbie's representative. And this is his bond and tax elections bill that we think is very commonsensical, and it is also a constitutional amendment. It passed unanimously, 12-0, so
And
that was a
yeah,
good thing.
and it was good to be there. Fewer tax elections, thank God, got to be held only when there is a statewide gubernatorial or congressional election on the ballot, so more people get to go vote on these local tax propositions, and you're not just having government employees and contractors showing up, and you have 200 people voting, and you get a significant tax increase when you didn't even know it was on the ballot, and the only people voting are the people who directly benefit from it. So I think it's a very, very good bill. And it passed out, as you said, unanimously in committee. I don't see how this is going to have a problem.
No. Unless they put this, well, it's a constitutional amendment. I was going to say, unless they put it in an off election cycle so that nobody knows to go and vote.
You mean put the constitutional amendment that would ban tax hikes in off election cycles? Put that in an off election cycle?
Yeah, exactly.
Oh my gosh, only you.
Wouldn't put it
Only
past
you.
him. I wouldn't put it past him.
I wouldn't put it past him either.
Although I would hope, and I'm sure he did, that Representative Fontenot clearly stated what were the acceptable terms for when this would be
When this
brought
should be
as an
heard,
amendment.
yeah.
Yeah, when it should be voted on. All right. In Senate Judiciary C, also on Tuesday, Representative Jay Morris has SB 201, which is a bill we oppose. Chris, you oppose it very strongly because it is changing the definition of parole eligibility for juveniles.
Yeah, it's a juvenile bill. 90% of the bill does nothing except restate in different words what the current standard of review, appellate review is in juvenile criminal cases. They can't mess with a trial judgment, the appeals court, unless it was, grossly, grossly wrong. They have to defer to the fact finder because they were there, they saw the evidence. So that's what they have to do. But so it's all fine, other than the fact that there's a part in this bill that repeals this. Right now, the law is that complete denial of parole for a juvenile should be reserved only for the worst offenders and the worst types of cases. Other than that, as a general rule, parole should be made available under proper circumstances. This repeals that. And I don't understand why. This is a good law, and it
Makes sense.
it makes perfect sense that a judge, in considering whether a juvenile criminal offender is eligible for parole, would be able to consider how serious the offense was and how, in his background and what type of offender he is. Why would you want to repeal that? I don't understand it. So I know this is going for a vote on the Senate floor, but we're going to put our 10 cents in on this and at least get an explanation for why he's trying to do this.
Yeah, because in our view, it completely undercuts any incentive for personal redemption, right? You have no incentive to rehabilitate any quicker or to do any differently if you're going to be stuck in jail just as long as if you don't do any work on yourself.
Exactly. This, to be honest with you, Danielle, this is really consistent with the broader theme of the criminal legislation that our legislature has brought, in which they seem to completely, they've really eviscerated in many respects the positive avenues and possibility of being rewarded for genuine rehabilitative efforts while incarcerated. I don't understand that. I mean, it's just natural that a human being would want to try to do better and improve himself while incarcerated if he knows that he can get a reward for doing so, and a good reward, a just reward.
Yeah.
Why would they take away these incentives? I don't understand it.
And Chris, if we want to see a pattern here, we can see stricter judgments or stricter treatment in putting 17-year-olds into adult courts in a lot of cases now, rather than being in juvenile courts. We have seen Senator Cloud try and take away their physical contact with a judge until that got called out. And so they were going to be basically scolded by Zoom, which if you are a child who was basically raised on TV, video games, and your phone, then having someone scold you through a screen is probably not going to have the intended or desired result. And then top it off with this that says, no matter what you do, you can never get out until the day is done.
It's unbelievable how heavy our legislature is on punishment and how light they are on rehabilitation. And I believe that every minor has a hope for rehabilitation. Very few of them have been what's called irredeemably corrupted by the time they're
Yeah.
16 or 17 years old, and they all have a capacity for rehabilitation. They're looking for hope. They don't want to be bad. And I think it's unfortunate that our legislature has been as punitive as it has been. And I'm not saying that we're not for law and order. We are very much for law and order when it's appropriate and it achieves a meaningful policy objective. But I think too often our legislation has not and will not.
Yeah, I agree with that, Chris. Okay, next up, Senate Bill 185 by Senator Thomas Presley. And this was the bill that we talked about this on Tuesday. It's his non-disclosure agreement prohibition on contracts, I guess, with child, basically victims of child sexual abuse are never going to be put in a position where they're unable to speak about their abuse.
Yeah, and this Senator Presley voluntarily deferred this bill. You have minors who enter into these settlement agreements for sexual abuse that they have been victimized by either by a company or by the church or whoever it is, and it is seriously traumatizing. And they enter into these agreements. They settle their cases. They receive money. But part of the settlement is a non-disclosure agreement that they, for the rest of their lives, cannot talk about their trauma, cannot talk about their abuse to anyone at any time, at any place. And, the objective of Senator Presley's bill is to make sure that they do not lose their voice within the context of settling these cases. The problem, Danielle, one of the main problems that was brought up by Senator Luno and why it was deferred was because the bill would have retroactive application. A lot of people have already settled these cases, and if this applies retroactively, they would be reversing or abrogating a contract that has already been entered into that includes these NDAs. And the question is whether or not that would be constitutional, because these were contracts entered into by private parties and the victim agreed to these NDAs. And they don't want to be in a position where it's challenged for unconstitutionality and they lose. So they have to work on that. But I certainly believe that there has to be some legislation passes that make sure that victims of this type of trauma are not routinely silenced in order to settle their cases. And they put a lot of pressure on them to sign these NDAs in order to settle these cases.
Yeah, and you also think, Chris, that a lot of times these are powerful or very well funded institutions in a lot of cases that are being sued for enabling child sexual abuse. I mean, you've talked about it. The Catholic Church, the place that was the genesis for this legislation is a massive multi-million-dollar a year summer camp venture. So these are organizations that your average Joe can't just go up against. You can't just, I mean, you're up against extremely expensive attorneys who wield a lot of power in a local community. And so I think it's incredibly important that this law moves forward so that should someone find themselves in this horrific position, that they don't also have to fight the battle of getting out of an NDA or getting an NDA pushed down their throat.
Exactly. That's exactly right. And there are some victims who say, "Well, I'm sorry, I'm not signing the NDA," so they go to trial, and then they have to go through, a stressful, brutal trial that
Yeah.
sometimes traumatizes them even more.
Yeah.
And so there's got to be a solution. I really admire Senator Presley for bringing this, and hopefully something can be passed that is effective, but does not raise the specter of some kind of a constitutional challenge.
Yeah, absolutely. And he has brought some really important bills to support people who find themselves in very unfortunate situations. We recall the bill he brought because of the situation with his sister. Was it last year or the year before, Chris?
2 years ago.
Yeah, where her husband tried to poison her and basically kill her baby with like over-the-counter abortion pills in Texas. Unbelievable.
Yeah, and it took a lot of courage for her to come forward, and
Yeah.
he was by her side the whole time. Yeah, that was, and he came on the show and talked about it at that time.
Yeah.
It was really, really compelling story.
Yeah. So he is a champion for the little guy, and I appreciate that about Senator Presley. Okay, next up, Chris, Senate Bill 125 by I guess it's by Senator Boudreaux, and this is a compensation cap bill as well. You are not happy with the way you see this shaping up.
I'm not real happy with it, because the bill passed out of committee. Let me just tell you what the bill does. This is for people who have been wrongfully convicted and wrongfully incarcerated, sometimes for many, many years. So this bill would increase the annual cap on their compensation that they can receive, and it would also increase the number of years that they can receive it from 10 years to 15 years. And my question, the big red flag look, all his bill originally would have done would have increased the annual amount, but I think it would have still been 10 years. The amended version takes it to 15 years that they can receive it, and it increases the amount that they can receive. The question is this: what if someone's been incarcerated for 25 or 30 years falsely? Why are you saying they can only receive compensation for half of that, let's say 30 years, and now it's capped at 15 years? What about the other 15 years that they were deprived of their liberty and their
Yeah.
freedom? Why shouldn't the government be responsible for compensating them for every minute, every hour, every day, and every year that they were wrongfully incarcerated? It's almost like the committee sitting up there saying, oh, we're doing them a favor by giving them, a few years of compensation for the years that they were wrongfully. No, you're not doing them a favor. This is called retributive justice. You messed up. It was your mistake. You incarcerated them falsely. You caused them to lose many years of loss of their liberty, and it's not too much to ask for you to have to compensate them for every year of freedom that you falsely deprived them of.
Yeah.
That's the problem that I have. And of course, Senator Clout, was up there talking about that, and it's the 15 years, right? And other people. It's like, I'm sorry, I don't want to hear that nonsense. You go lose 30 years of your liberty and then have the government tell you that you only get to be compensated for 15 years of it, and explain what the rationale is for that.
Yeah.
No, this bill ought to provide that every year, every minute that a person was wrongfully detained or incarcerated by our government, they should be compensated for that, period.
Yeah. And I can understand having a cap on this just because we, the people, are paying for a small group of people's mistake, right? The government obviously did put them behind bars. A jury most likely did this wrongfully, or a judge. But so I could understand that there would be a cap on this. Otherwise, we could bankrupt the state.
Absolutely.
But let's not forget that, like you said, Chris, they have been wrongfully imprisoned. They deserve compensation. They deserve the acknowledgement of the state of wrongdoing. And
Absolutely.
And
the
I'm
rationale, Danielle, the rationale for the cap, by the way, you just said it very insightfully, is the fact that unlike in the case of private corporations, multi-billion-dollar private corporations, this is funded by the taxpayer. So
Yeah.
there is a compelling policy interest in putting some kind of a reasonable cap on this because we're the ones paying it. But there's no policy interest in curtailing or cutting down the number of years for which they should be compensated. And I just do not agree with that. Obviously, if this is the best we can get on the bill, well, yes, because it goes from 10 years to 15 years, and there is a marginal increase in the cap. So yes, we'll go with it, but it's absolutely not ideal. And on some level, as a matter of principle, it's really insulting to people who have been wrongfully incarcerated.
Yeah. Chris, Rachel in the chat here is asking, is there a limit to the amount of wrong a person can be subjected to by our government? And I think the answer is only the amount that you're willing to take.
Well, you know what? There's a great quote, Rachel, that said, the amount of injustice a government can perpetrate on its citizens is directly proportionate to the amount of abuse the citizens are willing to accept. So we're the ones who put a stop to it for sure. And we just got to keep moving forward and keep fighting. And collectively, I still believe we're a lot stronger. We need more Rachel Bertrands in the world, by the way. I met her a few weeks back, and what a great American.
Awesome. Thanks for chatting in, Rachel. It's a great question. All right, let's move along here, Chris. House Health and Welfare yesterday. Representative Mike Bayham brought a bill, his House Bill 926, and it would prohibit the use of vaccine status to determine your ability to enter a public building. This, we were supportive of this. I mean, in some ways we could say it doesn't go far enough, but it was a good, I mean, I think it would have taken good steps forward. He voluntarily deferred this bill. Chris, I believe you testified on it.
I did testify on it, and I don't believe that any institution, whether it's public or private, should be able to discriminate against any American citizen based upon whether or not they got a vaccine. I mean, that's a matter of fundamental medical autonomy. It's a matter of medical choice. And,
it's a matter of medical privacy. How about that?
Personal privacy, informed choice. The government has no role in that. And they certainly have no right to discriminate against someone entering a public building or accessing public commodities based on whether or not they've gotten a vaccine. We testified in favor of this. Unfortunately, there were a number of Republicans who were absent yesterday, and the composition of the Health and Welfare Committee yesterday, they wouldn't have gotten it through. And so the bill was voluntarily deferred, and Representative Cruz said that was basically the reason why. But it's coming back, hopefully with a full deck of Republicans on that committee this session to get it through. It's an important bill, but again, Danielle, as you said, not really broad enough. There is a bill that's coming up, Jay Galley's bill, that is very comprehensive, that we're going to be fighting very, very hard for, but I don't know if we're talking about that today or not. But this is a good bill as far as it goes, and hopefully comes back and gets through. But if Galley's bill gets through,
there's no need for it.
This one, we don't even need this.
Yeah. Debbie's saying Baralt's questions on that bill was surprising. You were in there, Chris? Do you know what she was asking about?
Well, what I remember specifically, I remember Jackson's questions, because he was, I don't specifically remember Baralt. I guess I had to get out of there at that point. I don't know, but I want to hear from Debbie what Baralt was asking. I vaguely remember, but I know what Jackson was asking. And he was saying, are you saying that, and I responded directly to Jackson, and he was saying, Representative Bayham, are you saying that, I mean, don't, like for instance at the Superdome, they have a right to tell people who don't have shoes on that they can't come into their facility? Don't they have a right to say you have to wear a shirt or you don't get to come in? And I was like, and Mike didn't really respond. I didn't think, he did his best, but he didn't really respond in the way I thought was appropriate. I said, when I testified, I said this, I said, Representative Jackson, in my view, it's the difference between something that's discretionary. Of course, that's a matter of taste. That's a matter of personal choice. They have a right to say you don't get to come in if you don't wear shoes. But they don't have a right to tell you that you have to inject a needle into your body and make a medical choice that could have profound consequences to you and your family if you don't want to in order to come into a public building. There's a big, big difference between the two. One is a violation of a core constitutional right. The other is a matter of discretion. So, and I told him that. But again, the votes weren't there. But I would like to know, be reminded of what Billings Baralt asked.
Debbie says her position on vaccines indicated that she was opposed, and she also added that you had an epic response to Jackson. So
Oh,
thanks,
well,
Debbie.
she's Debbie, you're so kind, so kind. No question about it. By the way, I've got to talk to Debbie about. We're going to get to it, but Debbie,
Yeah,
you got
actually,
to stick around.
it's this next bill, Chris, House Bill 611
Oh
by
yeah,
Representative Amy Freeman, and this bill was going to impose licensing requirements on private facilities that provide pregnancy services to
yes.
women.
Ended up being voluntarily deferred.
Beautiful.
This is a bill. Danielle, there are. Debbie probably knows this, but there are probably 35 or 40 private crisis pregnancy referral centers in the state of Louisiana. They already operate under the supervision, the vast majority of them, of a licensed doctor. There is no evidence that any of these places are abusing any women or acting in any way other than what's in the best interest of these women. They're funded by charitable organizations or donations. My mom, the reason why this bill meant a lot to me, opposing this, and I'm so glad that it was deferred, is that my mom founded the first crisis pregnancy center in my hometown of Shreveport and ran it for 40 or 45 years without any help from the government, and very thankful that the LDH was not imposing these onerous licensing and regulatory requirements on her pregnancy referral operation, with penalties, by the way, Danielle, of $5,000 a day if you violate these provisions.
Are you
And
kidding me?
no,
These are
five
these are
thousand.
these are funded. These are often funded by donations, by people who are like-minded, by grants perhaps, but usually private donations or private. I mean, literally people just putting it out of their own pocket that are running it. That's insanity.
It's absolute insanity. There's no reason for this. This is just government overreach. And the ultimate goal, despite what they say, the ultimate goal is to put these people out of business or to make it
Yeah.
so burdensome for them to actually counsel these young ladies who are in crisis situations, desperate situations. You know why they hate this? You know why they hate this? This is just gets me fuming all over again. If these local charitable clinics, private organizations, were counseling these young girls to go have an abortion,
You're
do you
100%
think
right.
Amy Freeman would be sitting at a committee table trying to get them regulated by LDH in the state of Louisiana? I guarantee you she wouldn't be. The
Right.
reason why they're sitting there is because that's the opposite of what these charitable organizations are doing. They're trying to, and they're very successfully counseling these young ladies to have their child and bring their child to term. And that's why they're pro-life Christian-based organizations. That's why this bill was being brought. And the
Yeah.
last thing they need is to have LDH breathing down their throats. There was a lady who testified, Danielle, who has been doing this for almost 40 years. I was so impressed with her. I can't even remember her name. Maybe Debbie remembers it. But she was doing it for 40 years. And I was so impressed with what God only knows the number of unborn children she has saved and the number of young lives, girls who are pregnant, whose lives she has influenced so profoundly. The idea that anybody would think we need the government, LDH, getting their nose inside that tent, it just infuriates me. It
Yeah.
infuriates me.
Yeah, and Chris, let me see what Debbie said here. She said she'll send us the clipped video of Freeman, so many lies. She accused us of providing prenatal care. Mandy Landry took the helm next and expanded on the lies. She wants to know, how did Mandy Landry get on the H&W committees? A solid question. And she says that they accuse these people of practicing medicine without a license. I just want to get on my little soapbox here, Chris, and say, when did the government begin to determine who and who cannot help people, right? If you let's go back to the story of the Good Samaritan. What would happen if the Louisiana legislature was involved in the story of the Good Samaritan? They would say, "Oh no, you can't touch that man because you have not been licensed. You have not paid your fees to the government." So that we could tell you that you can help this man who's been badly beaten and left for dead. No,
Yes. By
no,
the
government,
time,
you do not get to tell us who can practice medicine. And you, I mean, your
well, they
definition of
do.
medicine is pretty broad. Yeah, of course they do. It's because we've allowed them to do it. And there's certain circumstances. Okay, do I want someone licensed who needs to perform surgery? Yes. Do I need somebody licensed who wants to offer natural healing to me? No. No. This is completely crazy. And any kind of counseling that people want to do, why do they need to go to the government to get sanctioned by that? Don't you think people have free will? They can go get counseling from anyone that they want to get counseling from. If they don't like what they hear, they can go somewhere else.
Exactly. Exactly. And your Debbie is right. They repeatedly raised the specter that these small charitable pro-life organizations are the specter of some kind of sinister or nefarious behavior on the part of these, and nothing could be further from the truth. The only thing that none of them ever produced was the slightest bit of evidence that any young lady has ever been harmed in any way by the activities of these charitable pro-life groups. Not one piece of evidence. But that's what leftists do. They come in and they raise the shadowy specter of evil and leave that thought in people's minds without producing one shred of evidence. And I take this very, very personally because of my mom's background. My mom would have been at City Hall or at the legislature if she had to walk from Shreveport in the 1970s and 80s and 90s to protest against a bill like this. And believe me, she probably would have been successful if I know my mom.
And Chris, Debbie said the woman who testified's name was Dorothy Wallace, and her organization is Caring to Love Ministries.
Caring to Love Ministries.
Yeah,
Yeah,
awesome.
I knew Debbie was going to be all. I knew Debbie was going to be all over a bill like this. Oh, and Amy Freeman. I'm sure Debbie remembers this at the end. I'm personally offended. I'm personally offended that anybody would suggest that anybody would bring this because it has to do with pro-abortion or pro-life, or that we want to shut these things down. We want to shut these organizations down. We just want good health for the baby in the mother. You know the best thing that you can do, Representative Freeman, to ensure good health for the baby and the mother is keep the government the hell out of it, because everything they touch turns to crap. So keep the government away from it. Let these people do what they do and help these young ladies bring their child to term and leave them alone. That's you. Let's just. That's all I have to say about this. I'm glad this was voluntarily deferred, and I hope it never comes back.
Yeah, hopefully she felt enough heat and opposition to not want to bring it back. And likewise for Mandy Landry's House Bill 931, also targeting pregnancy and baby care centers. It was saying that they could not condition their services on religious requirements, which on its face sounds fine, right? It sounds like it's probably already the law. But what really got me about this bill is that the chilling effect it has, because these small crisis pregnancy centers now have this idea of the government weighing down on them, looking over their shoulder, saying, did you say the name of Jesus? Did you talk about God in here? Maybe it made them feel uncomfortable. We're going to have to strip you of everything you have, take all your money, and shut you down.
Danielle, it's the most ridiculous thing you've ever seen. It's going to be in the top 10 most useless, unnecessary, most stupid bills of the session. And Mandy Landry has a good bill, a couple of good bills that we've given her credit for and that we're actually supporting. This is not among them. Like I said, and I'm just referring to my mom because that's the frame of reference that I have on this issue. My mom did this for 40 years. I don't think she one single time asked a young girl who was filled with distress and anxiety and fear when she found out she was pregnant and alone, my mom asking her before she hugged her and loved her and did everything she could to help her, whether she was a Christian or what her level of spirituality was, or where she goes to church.
Or you have to come to church in order to get these services.
Yes, I'll help you, but we're going to go down to the church here first. And if you don't, never a part of it. And I guarantee you, if the ladies who testified yesterday in opposition to this bill were asked that question, they would look at you like you were absolutely nuts. Are you kidding me? We're here to save lives. We're not here to impose some kind of religious litmus test. Yes, we're Christians. Yes, we're a faith-based organization, and that's where we derive our strength and resilience and perseverance to do what we do every day. But it's insulting for her to bring a bill predicated on the idea that we have this epidemic in the state of Louisiana of these small pregnancy crisis centers imposing some kind of a religious litmus test on these scared, frightened young girls before they'll help them. It's the dumbest thing you've ever seen. I don't even know. And it was, fortunately, maybe Representative Landry also came to the conclusion that it was stupid because it was voluntarily deferred. And by the way, we sent in opposition to the committee, and we have put in, they know that we're very much opposed to this bill. And I'm glad it's gone, and I hope it doesn't come back.
Debbie says it's coming back Tuesday alongside 2 more bills attacking pregnancy centers. So if pro-life is an issue that is near and dear to your heart, plan to be at the legislature on Tuesday morning, it sounds like. And she says it's absurd that a loving, compassionate ministry needs policing like this. Absolutely, it does not need policing like this. You're 100% right, Debbie.
Debbie's right. And the ultimate goal, Danielle, regardless of how it's camouflaged with under the most glowing of pretexts, the ultimate goal here is to burden these small charitable organizations because they're pro-life and they're faith-based.
Yeah.
That's where the hostility comes from, or none of these bills would be pending in our legislature.
Yeah, absolutely. And Rachel says, amen, may your mother's legacy live on forever. And I think it will.
Thank you, Rachel.
Okay, Chris, I think we're going to have to shift gears now. Totally different topic set. But it's very concerning to me that that at least this bill would be coming back. And I just want to say, when did the atheists get the moral high ground and become the experts in how to treat women in pregnancy crisis? That's what I want to know.
Exactly. And of course, as you know, there's generally only one solution there.
Yeah.
Have an abortion.
Yeah.
Kill the baby, and then we move on. So, one size fits all for them.
Yeah, absolutely. All right. Well, yesterday there were some interesting happenings in the House and Governmental Affairs Committee. This bill, House Bill 1071 by Representative Jack McFarland, raised our eyebrows just in taking a look at the title of it, because there seems to be a lot of reasons that the legislature can find to provide exceptions to the public records law. It seems like any issue they may be working on, or any issue they may have some kind of connection to, suddenly needs to not be able to be seen by the public. This one is with respect to records for aerospace facilities or activities. And we were opposed to it on its face, Chris, but you took a deeper look at it, and it seems to be a pretty broad brushstroke here.
Yeah. Any record, any document, any and all information related to the development or the building of aerospace facilities in the state of Louisiana taxpayer funded, would be exempt from public records. We wouldn't be able to see it. It would be an exception to the public records law. And that is very, very dangerous. And we're talking about documents and information that even the Department of Defense has not declared classified information.
You're
And
talking about contracts.
we're talking about contracts. We're talking about contracts that commit potentially millions and millions of dollars of our money
Yeah,
to
maybe
private contractors.
perhaps employment records.
Employment records. Why, there should never be um, a blanket ban on the public records law in cases like this. Here's the way I look at public records. I think every document in the hands of our government should be presumptively a public record if it involves a matter of public concern, and certainly if it involves the expenditure of our money. And if they want to make an argument that it should be classified either for reasons of security or for some other reason, then they need to come forward and prove that on an individualized basis. But the presumption should always be in favor of disclosure. This is a government of, by, and for the people, and you should not be able to do the people's business in the dark behind closed doors. So the burden should be on you to come forward and prove an exception. That's the bottom line. This bill sweeps way too broadly, and we're going to be putting in some heavy, heavy opposition on this as it moves forward. It never ceases to amaze me, Danielle, but it's becoming a little less so now as we continue to grow. It never ceases to amaze me how little our legislators question or scrutinize some of these bills that are coming through these committees on incredibly important things, and yet they'll sit there and go over every jot and tittle on other bills that are far, far less important. But this is
Yeah.
an extremely important piece of legislation, and I think it's terrible, the current posture of this bill.
Yeah, and what's concerning is that we both have this kind of spidey sense that this is going to try and accomplish something that we can't see. When there's a broad blanket like this, usually there's some nefarious purpose that's very specific. And we saw that with the NDA legislation last year or 2 years ago that we
2 years
fought.
ago.
We didn't know why they were bringing it, but we knew they were bringing it for something that was not going to be good. Obviously, that has proven out in the last 2 years. This bill, I have very big concerns about. It makes me wonder what they either want to build that we don't want them to build, what they want to fly over us that we don't want them to fly over us, or what kind of contracts they are signing that we don't want them to sign. Because why should this be undisclosed to the public, who, as you very well pointed out, Chris, is paying for it?
Exactly. I couldn't agree with you more, and we're going to be tracking this very, very closely.
Yeah, and it's worth mentioning that it passed unopposed, absolutely
Yeah.
unopposed in House and Governmental Affairs. Representative Boyer, Beth Billings, Foy Gadberry, Mike Johnson, Ed Larvadane, Dixon McMakin, Candace Newell, Rodney Shammerhorn, Polly Thomas, Joy Walters, and John Weibel all voted for it. The rest of the lot were absent. Nobody voted against it.
Yeah, and there were a number who were absent. But I think it's very, very dangerous if this bill gets through in its current form. And of course, Danielle, they always, the way that the author postures the bill, of course, is that, aerospace, agreements and records deal with often national security and state security issues, and therefore they should be off limits. And the legislators listen, so yeah, I can understand that. I can understand why that would be an exception to the public records. And they just leave it at that. And they don't understand really the broader implications of what this legislation will do in
If
a
it's
society that's supposed to
classified,
be transparent.
if it's classified, it's already an exception to public records law.
That's the point. And many times, and that's exactly one of the objections we have to this. So they're saying even if it has not been classified by the Department of Defense or by the federal government, therefore It's not classified. It's not classified. They still get to classify it essentially on the state level.
Come on.
Come on.
Yeah. Okay. House Bill 529 was the next one up by Representative Mike Bayham. We vigorously opposed this. You were spitting mad when you even saw this bill come up when we were reviewing bills at the beginning prior to session. It is Senator Sebaw's companion bill that would take the Bessie board, the board of state board of elementary and secondary education. Sorry,
Not very euphonious.
That it would take it out of the party primary system, which is already kind of got a lot of, I don't know, exceptions to it. This is the legislature that loves exceptions.
Yeah. Right now, because of our legislature, we have a quasi-closed primary system in Louisiana. And basically what that means is Bessie is one of those offices that's in the closed primary. And what Bessie is, it is the most powerful education board in the state. It governs, directs, forms policy for every public school in the state of Louisiana. Curriculum, agenda, priority, all of it. So basically, it is from that perch that our children's minds are formed and their ideology is influenced from the Bessie board. There are 8 Bessie board elections up in 2027. How critical do you think it is that we maintain the closed primary system so that Democrats don't get to come over into our primary and infiltrate it in basically a jungle primary system and make sure that we elect rhinos and leftists to the Bessie board so they can continue to indoctrinate our children from that position? I think it's extremely important. Well, Mike Bayham, his bill would eliminate the closed primary system for the Bessie board and go back to the jungle primary system. When I tell you how hard people like Katie and Christy Hike and others, Paige Lowry, worked to get a closed primary system so that we could make sure that good conservatives are on the Bessie board, I could go on and on about it. And now we have legislators, Republican, coming in there trying to dismantle it. Fortunately, it got I believe it was
It failed
defeated
in committee 9-3.
Okay, yeah, there was a vote, and it was killed 9-3. Fortunately, we have raised a lot of ruckus about Senator Sebaw's companion bill on the other side, which does the exact same thing. So 529 went down yesterday, and hopefully SB 49, Sebaw's bill, will go down the same road, and we don't have to worry about this anymore. But it is insulting that any Republican would try to dismantle the closed primary system in this way.
Yeah, and Beth Billings, Les Farnham, and Foy Gadberry voted for this bill. And Chris, I just want to ask you, because I'm not sure why this didn't occur to me before now, but aren't the statewide elected offices part of the closed primary system now? It's just the state legislature that remains on the outside, right? So this is not good. If that's the case, this is not a standalone primary. People will be voting for AG. People will be voting for treasurer, commissioner of insurance, and governor in the same election. Am I wrong?
I don't believe that currently all of those offices are in the closed primary system. There was a cutout. I know the governor was cut out. The legislature was cut out. There are a number of offices that were cut out. And the reason why they were cut out is because our legislature did not do its job to make sure that we had a comprehensive closed primary system when Julie Emerson brought her closed primary bill a couple of years ago. They should have done that. They shouldn't have had all these exemptions and these carve-outs. And if they had done their job then, we wouldn't have a standalone Bessie closed primary right now to deal with that they're complaining about having to spend $6 million on. And that's why we need to go to the jungle primary, so we don't have to spend $6 million on a standalone closed primary election. Well, I'm sorry, you created this problem. You're going to come in here and pinch pennies in order to solve a problem that you created and sacrifice the integrity of the most powerful education board in the state of Louisiana in the process. Sorry, we're not going along with that, and we're not going to do that. And I'm
Yeah, Chris.
surprised that Republicans would bring this bill.
Well, I'm not. I'm not surprised that Republicans would bring this bill. That's ridiculous to think that Republicans wouldn't bring this bill. It's been absolutely self-defeating since this legislative cohort has started, Chris. And I would like to remind all of the viewers that the person who instigated the destruction of the party primary as it was intended to be was Senator John Kennedy. So you can think he's funny. I think he's the funniest member of Congress, no doubt, hands down. But he is the person who waded into this and made it so that the party primary, is not applicable to all offices.
That's a very good point, Danielle. When this bill came out of the House a couple of years ago, it was a clean closed primary bill, and it did not, importantly, allow independents, 800,000 or so in the state, to vote in Republican primaries or in Democrat primaries. It was only Republicans. Senator John Kennedy was very influential in watering down what was originally a very good piece of legislation to allow all these independents to vote in our primaries. And of course, Governor Jeff Landry went right along with it. And I think it's important to remember that.
Yeah, and I also want to remind people that Governor Landry campaigned on closed primaries, but now that perhaps he's recognizing that they're not to his ultimate advantage, they are starting to get attacked, and I think people are trying to strip them out as a result of that. So I think it's very disingenuous that this is being attacked. I think it's completely ridiculous that the Republicans in the legislature would go for this. I also think, look, doesn't Representative Bayham sit on the Republican State Central Committee? And isn't it the position of the Republican State Central Committee that it's not even the position of the legislature? It's not the duty or right of the legislature to determine how party primaries are conducted. So why would someone who sits on that body be bringing legislation to undermine the other body that they sit on?
That's such a great point, Danielle, because the RSCC, the Republican State Central Committee, of which Mike Bayham is a member, has passed a formal resolution to make Republican primaries completely closed and, completely closed and embracing the importance of closed primaries. That is their formal resolution. He is on the Republican State Central Committee. And here he is sitting in front of a committee to eviscerate the closed primary system for our Bessie elections. It really is quite incongruous. But I have to make one last point here because I saw this yesterday. Lieutenant Governor Billy Nungesser is a huge opponent of closed primaries. He's a Republican. He's a huge opponent of closed primaries in Louisiana. I completely disagree with his position on this. I think he said it's going to seriously damage the Republican Party if we have closed primaries. So let me, in response, state just quickly why they are so important to have clean, closed primaries. When you have a jungle primary where where you just have one primary election where Democrats and Republicans are all thrown in, and everybody, all Democrats and Republicans, they come in and vote, and the top two emerge to a general election. Let me tell you what the problem is there. It dissipates the voice of a majority of Republicans in Louisiana when you come in and allow people who are not members of the Republican Party to vote in what should be strictly Republican primaries. The reason why we are electing liberals and rhinos to our legislature and to many other offices in our state is that we don't have a strict closed primary system. We have a substantial number of conservative Republicans, a majority in the state of Louisiana, And they keep asking, why do we keep electing all these rhinos? The reason is because our elections are being infiltrated by Democrats who are coming in and voting for liberal Republicans in order to sabotage our elections. That's what's going on.
No,
So
and I would tend to disagree with you a little bit, and I'll say why. Because if there's a strict closed primary, you vote differently than you do in a jungle primary. Let me explain. So in if I'm going into a strict closed primary and I'm voting for who I want, I'm voting for the person who most accurately represents my point of view. That is who I'm voting for because it's going to be there's probably two, three people. There's going to be one who most closely represents what I want. So that's who I'm voting for in that case. In a jungle primary, I'm voting for who is the most palatable person that can get elected in this situation. That's a different person. You're not voting for the most conservative person in that situation. You're voting for the person who's least worst that can get through this mass situation. So I
that's a
think
great point.
that to me is the problem with the jungle primary.
Yeah.
And I think that's why the
yeah.
liberals are getting through.
I think that's an excellent point. So in a strict closed primary, your criteria in determining who you're going to vote for is different than the criteria if
It's a
this is.
psychological difference. You have a different approach
In other words,
because you're getting to a different place, right? I mean, you could have two Democrats in a runoff for a jungle primary, so you have to pick someone who's going to beat the Democrat if you're a Republican. If you're voting in a closed primary, you vote for who you want because chances are, regardless of whether they get it, there's still going to be a runoff. And so you'll get who then you can make another choice based on who you can live with after that.
exactly. Yeah, that's an excellent point. Yeah, excellent point. So anyway, back to Baham's bill. This was, you know, defeated, and I hope that SB 49 goes the same way. Seaball's bill.
Yeah. Yeah, I hope so. At least he can take this as a warning shot that it's not going to be a walk in the park for him.
Absolutely.
All right, Chris, let's trot along here because I know we're camping out on some of these, but we haven't gotten as much time this session to sit down and opine and rant about all the bills. So this is a good opportunity for us. Next is House Bill 250 by Representative Chris Turner. Look, there's a couple bills this session that just turn my stomach, and they are bills that I put under the moniker of legalizing corruption. And Chris Turner's bill, to me, does that. This is disclosure of information by boards and commissions. Chris, you can spell out what that means in practice. But it did pass. It passed yesterday.
Yeah, I mean it basically does away with the requirement that a member of a board or a commission has to disclose whether or not an immediate family member has a contractual or financial relationship with the state and or specifically with the board on which their family member is serving. They don't have to certify that anymore. I'm like, why would you not have to affirmatively certify that there's no potential conflict of interest by an immediate family member that conflicts with your service on this board? I don't understand that, but yeah, they voted that through yesterday, and I don't know exactly why. Maybe they didn't really understand what it was doing, but we're going to make sure that everybody on the House floor knows what it's doing, and that they consider very carefully whether they're going to vote for this, because this to me, Danielle, is a textbook example of why this and Mellerin's HB 210 of why people on the national level look at our state and say what is going on in Louisiana and why our state has the reputation of being among the most, if not the most corrupt in the country. It's because of laws like this that would be no-brainers in places like Texas, in places like Florida and other places. We pass bills that do this, that obscure potential conflicts of interest from the people.
And Chris, this is a law. So would this mean that someone, like, if this bill, okay, if someone before this bill passes does not certify that they have a conflict of interest, they do have a conflict of interest, and then they somehow benefit from that conflict of interest, what's the current penalty for that? I mean, generally, you don't have to know dollars or anything, versus what the general penalty is for this. And I mean, basically, I want to understand, is this an ethics sanction or is this actually breaking the law?
This is an ethics sanction that can be met with substantial fines and penalties from the state ethics board. That's what this is, and the idea that this would be permissible for someone who is serving on a powerful board or commission not to have to affirmatively certify to the ethics board and publicly certify that they don't have an immediate family member that has a contractual or financial interest in his service on the board, or a contractual or financial interest with the state generally. They have to affirmatively certify that I don't have an immediate family member with an actual or that I don't have an actual or potential conflict of interest in serving on this board because of a relationship, contractual or financial, that one of my immediate family members has with the state of Louisiana or has with this board. And it just seems that that is a requirement that should always be imposed on someone serving on a powerful board and commission. And this legislation does away with it. And I think it's truly unfortunate. Now, it's not done yet. Still got to go get voted on the House floor and then over to the Senate. So we're going to be raising awareness about this HB 250. And you know what the reason was, Danielle, that Chris Turner gave? I'm sorry, but I don't know what my family members are doing. I don't know what kind of financial entanglements my family members are in. I don't even know what some of them do for a living. So it's not fair to make me have to affirmatively certify that I don't have a conflict of interest because of their relationship with the state. It's just not fair.
Spoken like someone who has a family contract with the state.
Right. Spoken, frankly, like someone who brought a bill while owning a pharmacy to allow pharmacists to administer vaccines of all kinds and sorts without a doctor's prescription for kids age 2 to 17. That's what it sounds like.
Yeah. I just want to mention, Chris, who voted in favor of this bill. And it was everybody that was present, but it was Representative Boyer, Billings, Gadberry, Mike Johnson, Ed Larvadane, Rodney Lyons, Rodney Shammerhorn, Polly Thomas, Mark Wright, and John Weibel. And those who were absent, I'll just mention the Republicans who were absent, Les Farnham and Dixon McMakin were not there for the vote.
Yeah. So I don't know whether some of these people were asleep or what was going on, but again, we're going to make very certain on the House floor that this is addressed.
Yeah. Okay, another bill that this bill would retroactively legalize corruption, and it's Mellerin's House Bill 210.
Yeah, and I
Another one that
testified
also
on this.
passed.
Yeah, I testified on this one yesterday, and I just think it's absolutely unbelievable that this retroactive get out of jail free card, members of boards and municipalities who committed ethical infractions before those ethical infractions were no longer ethical infractions. They had to go back and clean that up. So it's sort of a retroactive get out of jail free card. They're retroactively saying that what you did in the past that violated ethics laws, because we passed laws that make them now not unethical, you didn't break the law then, even when there were stricter ethics laws on the books. So it's unbelievable. Yeah. And I just sat before him and said, it sure would be nice if Louisiana citizens could come down to the legislature and pass, legislation that gave us retroactive exoneration for past mistakes, past ethical infractions. Why does this apply just to members of boards and commissions, but Louisiana citizens certainly would never be able to benefit from this type of legislation? It's infuriating, quite frankly.
It's because you're standing in the way of another potential revenue stream, Chris. That's why.
Well, I think you're right, Danielle. But this 250 and 210 are going to be, believe me, we're going to be heard loud and clear on the House floor on both of these.
Yeah. And we just have a couple left. I do want to read Rachel's comment in the chat. This was, I believe, going back to our conversation about Bam's bill on the closed primary, or putting Bessie back into a jungle primary. She says it's common sense. When we build a fence, we have cattle on either side, but not on top of the fence. That's a
I love it.
great analogy.
I love it. I love it. And
Yeah.
just to add to that, Danielle, here's the deal. Just like if you own a country club, just like if you own a hunting club or whatever, the Republican Party is a private organization. If you want to participate in our processes, including voting in our primaries, you have to do one thing that's not particularly onerous. 3 words: become a Republican. We don't allow non-members to participate in our processes. Just like any other organization in the country, become a member. If you want to vote Republican, your ideology obviously is closer aligned to the Republican Party than it is the Democrat Party. Just become a Republican and we would welcome you in. But if you don't do that, sorry, we can't allow you.
I'd like to see a lawsuit on this, Chris. I would very much like to see a lawsuit brought by the Republican State Central Committee or brought by members of the Republican State Central Committee to say, you know what, legislature, get your nose out of our business. You can wear whatever label you want. You can wear whatever label you want, but we're going to do this our way.
We keep hearing about it, Danielle. We keep
Well,
hearing that they're
yeah,
going to be bringing
I
this
bet they
suit.
sent a strongly worded letter too.
Oh, yeah, probably a strongly worded letter. But the point is, we have to fight for closed primaries, continue to, especially now that they're under threat from our esteemed Cameron Henry, the president of the state Senate, who is saying that closed primaries are breathtakingly confusing for Louisiana citizens. So I think we need to move away from the closed primary system. Sorry, buddy. Well, that's insulting to the average Louisiana voter that you don't think they
Also,
could
you created the
comprehend it.
problem.
And
Yeah.
also you created the problem. So don't give me that nonsense.
Yeah. All right. Let's talk about a couple other bills. This one, you have some real problems with. It was heard yesterday in the Senate Commerce Committee, SB 389 by Senator Patrick Connick. And this is a bill about agents and athletes' contracts with, I guess, the teams or the schools.
Yeah. It's really a regulatory bill that's designed to protect these young athletes from predatory agents. These agents will come in and they'll sign a contract with the young athletes. When the athlete is endorsing certain products and allowing companies to use his name, image, and likeness, if like he's a famous college player or whatever, and they have agents who represent them. This legislature governs the agreements between an agent and a young athlete. And I understand what it's designed to do. It's designed to protect these young athletes from predatory agents who take advantage of them in these agreements. I get that. The problem is these are adults. They're not minors. Even the athletes in college generally are not minors anymore. The agent is certainly not a minor. And these are private contracts between 2 private individuals. And this bill makes them automatically mandatory disclosure to the Attorney General of the state of Louisiana, to the government. And I don't believe that the government has a carte blanche right to the details and the contents of private agreements between private American citizens. If there's a problem, if there's a challenge made, if one of the athletes suggests that I'm being taken advantage of, go see a lawyer. That's what we have lawyers for. And let him address the issue on an individual basis. I don't think the government should have the right statutorily to thousands and thousands potentially of these NIL agreements between private citizens. I believe it's government overreach, and I think that this bill needs to be amended significantly if we're going to support it.
Yeah. All right. Next up is a bill we haven't talked about yet because we weren't sure exactly how Representative Horton was framing it, but her House Bill 635 is related to crimes committed by foreign adversaries or agents of foreign terrorist organizations. This was an important bill and one that we think, Chris, would address the spread of Sharia law in the state of Louisiana, or nip it in the bud, more probably better said.
Absolutely. And the law, the significant part of the bill, it prohibits our state from enforcing any law of any foreign government or foreign organization, including terrorist organizations, or that is contrary to our Constitution, contrary to the laws and customs of the state of Louisiana. We just can't do it. It would be statutorily prohibited. And yes, it would apply to Sharia law. It would apply to any code of belief or conduct that is contrary to the Louisiana and to the United States constitutions. So I think it's important to get this through and to get it passed. I really don't believe, Danielle, I'd be surprised if this meets with a tremendous amount of opposition. I certainly hope it does not, but we're keeping an eye on it.
Yeah, it passed out of committee 10-0, and I think the amendments probably just strengthened some things. It said, and it looked like it maybe clarified and tightened up language. So hopefully this is in a good position to move to the House floor, and she does well with it there. We have a couple other bills to mention before we round this out today. And thank y'all for bearing with us, but this has been a hectic week. I mean, they jammed a lot into really 2 days.
Oh my gosh, unbelievable.
Yeah. So House
It
Bill
ain't no hill
7,
for a stepper though, Danielle, as my old coach in high school used to tell me when we were playing football and out there busting each other out. He said, Alexander, you better start running, son. This ain't no hill for a stepper. Saying we're steppers, and I don't care how hard the hill is, you're a stepper, so stop whining. Anyway,
all
go
right.
ahead.
House Bill 752 by Representative Kyle Green. I absolutely loathe this bill. I hate this bill with the fire of 1,000 suns, and I think that it needs to be set on fire. It is the bill that would authorize the legislature to make any kind of changes to legislative proceedings that it wants to. Basically, it can set the time, it can change the time that the legislature meets, it can change it would be a complete free-for-all in terms of when bills have to be proposed, what kinds of bills can be proposed. It's just a banana republic of a legislature, and it seems to be just sailing through no problem. My big problem with it, Chris, and you and I have vigorously discussed this. We had to read 1,300 bills in 10 days. That's what we had to do, and we did it. And then they were able to file some more bills. So now we have a list of probably 70 bills that we still have to go through that got filed during session. Me and you, just you and me. Who can do that if it's a freaking free-for-all?
Exactly.
I mean, who can do that? No one can do that except for what? Probably Lobby can do that. I'm sure the NRA can do that. I'm sure the Banking Association can do that. People who have full-time staffs of lobbyists.
And
And
they're
all
not, Danielle, but they're not even looking through all the bills. They're only looking
they're
through the
single
bills
issues.
that directly pertain to
Yeah.
them.
Yeah.
We're looking at every issue that pertains or impacts the Constitution and the core freedom of Louisiana citizens, which is a much broader category of bills.
Yeah.
So, and by the way, Danielle, they already have enormous flexibility in terms of the timing of bringing legislation. In the odd years, they can bring legislation up until 10 days into the session. And in even numbered years, I believe they can bring legislation up until 23 days into the session. Why is that not good enough?
Well, here's the thing. If the parameters that are codified in our Constitution don't suit you, don't run for office.
Well, exactly. It's like, do you not care that, you have small legislative advocacy groups out here that are trying to make sure that everything is scrutinized and studied? And if this passes, you're giving the legislature the authority to pass a bill saying that any legislator can file any instrument anytime during a legislative session, as long as they believe they have enough time to rush it through both committees and get it voted and passed in the chambers. That could be 2 weeks before the end of a session. It's like there's no way. You get a data drop, Danielle, when you and I are knee deep, getting exhausted 3 weeks before a session ends, and there's a 200 bill data dump on us at that time? It's not possible. And that is why this is a ridiculous bill, apart from the fact that, as a matter of basic principle, it invests more power in the government. And the last thing that we need to be doing is vesting more power in our government.
Well, also, I'm not really a big fan of deferring to the convenience of the legislatures at the expense of the citizens. We deserve the ability, the time to look at the legislation that they bring. And if they need to be thoughtful and they need to bring it in a timely manner. And I think that that's just being respectful to the people of this state. If you want to be lazy, if you want to be sloppy, if you want to bring your bill 3 weeks before the end of session, don't sign up to be a legislator.
I love it. And there's nothing else that I can say that expresses better my sentiment on this than what you just said. It's just fundamentally disrespectful to the citizens of our state.
Yeah. I just want to walk through what's happened so far with this bill. After it passed House and Governmental Affairs 2 weeks ago, it had some amendments, nothing to make it palatable by any means. Then it went to House Civil Law, and it had some more amendments, still not meaningful enough to make me want to like it in any way, shape, or form. Then it went to Appropriations and back to Civil Law, and now it's heading to the House floor for a vote. So we should expect that to be coming in the next couple of days.
And I love it, Danielle, when I love being out in the open when things get to the House floor. A lot of times, as I told you yesterday, Danielle, even some of these bad bills, I think that there are a couple of conservative legislators whose philosophy is this. Sometimes it's actually better to move something bad out of committee and get it on the House floor, to force a record vote by Republicans, to force them to go on the record about what their position is on some important issues. And so there is value, always some value, in getting a full House vote on legislation like this. And so we're going to have that on these bills. And I love the idea of letting all of them know where we stand. Here's what it does, and watch exactly how they vote on it.
Yeah, exactly. Well, maybe, Chris, I hope you are able to put out a note on this to the full floor and let them know how disgusting it is.
100%. Believe me, they're on speed dial.
All right, the next bill is House Bill 1085, and I kind of alluded to this earlier. And thank y'all for sticking with us. I know this is a little bit of a longer show. It's quite a bit longer show, but we'll try and wrap up soon
The
here.
Warriors.
We
The
want to
Warriors
make
stick with
sure.
us.
Yeah, that's right. We want to make sure that you get a full picture of what's going on. And Thursday has tended to be the day that we are able to do that. There's a little bit less going on at the legislature, quite a bit less going on at the legislature on Thursdays versus Tuesdays. So House Bill 1085, okay, Representative Larry Bagley for years has brought this bill to get rid of the state inspection sticker. I have long championed that. You have long championed that. Anyway, we're not going to get into that debate. Suddenly, Governor Jeff Landry has weighed in on this inspection sticker thing and said to Representative Bagley, look, I've got a deal for you. I will endorse getting rid of the inspection sticker if you give me this QR code that only shares the VIN number of the driver or
no
of the
worries.
vehicle.
Just the VIN number.
Yeah. This bill passed, let me see, I think it passed unanimously. Okay, it's made it all the way to the House floor. It passed the House floor 84-7 with only 7 Democrats voting against it. And I have a lot of problems with this bill. I spent some time thinking about this bill, and this is, if you can call me conspiratorial, you can call me what you want, but why do we need a QR code on our car that we can't read, right? Who can read that QR code? It's law enforcement, or it's technology. Let's say we can all read it, but probably not. You might have to have a specialized device to read it. So who's to say what else they might be putting on there? And if the bill limits what is put into that QR code, limits what data a law enforcement officer or a device from above is able to see about you, who's to say that they're not putting more in there, or who's to say that they're not going to put more in there? So this, to me, is a slippery slope. I think it builds the digital control grid. I think it makes us easier to track. I think it's creating a surveillance mechanism that we don't already have. We don't need more surveillance. It is creating a digital ID infrastructure. So if you are opposed to a real ID, why do you want a real ID for your car? That's essentially what this is doing. And the other thing it said is that it's moving local inspection. Okay, one of the big opposition points to getting rid of the inspection stickers has been, well, there's all these guys who are making money from the inspections, and we don't want to take that away from them. Well, guess what? This is taking that away from them, and instead, it's providing new contracts, probably much bigger contracts, to the people who create the QR code and the database for all this crap to sit in. So I think this is going to be more expensive. You don't have really an option to opt out of it, right? And I mean, are we going to ultimately end up in a place where they're able to give us speeding tickets from space because we've got this stupid thing on our dashboard?
Yeah. Well, they are already able, manufacturers are already able to extract metadata from new vehicles that show whether you braked too hard or you were
Yeah.
speeding in a certain zone, even if there's no accident or no issue with it, and send that information to your insurance company, all digitally. So it's not beyond the pale that you think, what is accessible through these QR codes that they say now all it will show is the VIN number. And they said that repeatedly, Bagley did in committee. By the way, this was a late substitute bill,
Yeah.
Danielle, very late. We didn't really have time to get our arms around it. I just told you a couple of weeks ago about this QR code stuff. But the point is, your concern, Danielle, if I'm understanding you correctly, is that this sets a precedent whereby the data that is accessible, that is otherwise private and personal to Louisiana citizens, could expand. The scope of this could expand dramatically.
Well, Chris, you just made me think of something that I hadn't thought of before, which is, okay, so they just want your VIN number. Well, what information does your VIN number have? What if the information that your VIN number has is the same information that's the information that your dealership is selling from your metadata to the insurance companies? What if it's just that the government wants to get in on the action and say, why do all these private companies get their data and we can't get our fingers on their data?
That's
That's
a
what I,
that is an excellent point, Danielle. Excellent point. I mean, think about it. I mean, just think about it. The metadata. You brake too hard, and
and your insurance
somehow,
goes up.
and your insurance goes up because your risk, in their view, goes up, even though there was no accident involved, no liability issue whatsoever. So, if a private company can get access to this type of information, why shouldn't the government be able to get access to similar information? And who's to say that the scope of data that becomes accessible through these QR codes could not expand? And I'm sure that it would. I understand totally your concern.
Yeah. So I am strongly opposed to this. I don't see a need for it. If a law enforcement officer needs my VIN number, he can pull me over and type it into his machine. That's how I feel.
Exactly. Exactly. So we're absolutely raising the awareness of these bills, Danielle, and every legislator is going to know exactly where we are. I really do believe that a number of these legislators who may have voted in favor of some of this stuff in committee either uh, realize that it's not going to pass on the floor, but they want these some of these rhinos to have to make a vote because nobody's tireder of these rhinos than the true conservatives in the legislature. They could never say that publicly, Danielle, because they have to work together and they sort of need each other on votes. But I have talked to a number of these conservative legislators, and they are sick and tired of the rhinos. They're as tired of the rhinos as we are. So I
Yeah.
believe sometimes they orchestrate this legislation to force a floor vote because it gives us more weapons. Either that, and that's one of the bases. And also, I think some of them maybe haven't fully read it or fully understand it, but they will.
Well, I think a lot of these bills, Chris, are positioned to be convenience for law enforcement, convenience for the driver, a net cost savings for the driver. Well, it's ultimately not a net savings for the driver if you think that you're saving them $1 or $2 when they get their inspection sticker, but then they have to purchase the database. Come on. That is ridiculous. It's absolutely ridiculous. So I think for me, there are bills where the consequences are not spelled out and the legislators don't feel they have time to dig into what this could possibly be about. And that's what we're here for. We are digging into what could this possibly be about. And we don't catch everything, but I think we're catching a lot.
We're catching a lot. And I'm so thankful that there is a process unfolding that gives us the time and the opportunity to make sure that these legislators are fully informed about what these bills do. And so that work that we do, I think, is absolutely critical.
Yeah.
And you're the one who basically, some of the time, Danielle, you're the one whose eagle eye sees some of these very, very dangerous provisions in some of these bills. I frankly don't know how you do it.
Well, it takes both of us, Chris, because you see a lot of stuff I don't see. And
Well,
that's a fact. Sorry,
yeah,
guys.
that's true. But most of the stuff that you see is actually there.
All right, let's talk about a couple bills that you are pretty stinking steamed about. Senate Bill 215 by Senator McMath and House Bill 219 by Representative Chuck Owen. These are restitution bills that have not seen the light of day yet and don't seem to have gained very much traction.
They don't. These are bills. There was a time in Louisiana when, in serious felony cases that were tried by a jury, 10 out of 12 who voted for guilt to convict was sufficient to put these people in jail for the rest of their lives. Since then, the Supreme Court has said that in serious felony capital cases, you have to have all 12. They have to be unanimous in order to find the defendant guilty. And this is in line with every other state now in the country. Before this happened, we were the only one of two states in the country that didn't require unanimous jury verdicts in capital criminal cases. So now we're in line.
Explain capital criminal cases.
It means that you can either it's mandatory life in prison or the death penalty,
Yeah.
one of the two. And in those cases, absolutely requires, because of what is at stake, a unanimous jury. That is reasonable, and now we're in line with the rest of the country. But, and it was the Louisiana Supreme Court that declared non-unanimous jury verdicts in those cases unconstitutional. But what do you do with the 1,500 or so people who were convicted in those types of cases by non-unanimous juries before it was declared unconstitutional? Well, they're sitting in jail now. So Senator McMath's and Representative Owen's bills would provide a mechanism of redress to go back and review those cases to determine whether or not they were in fact guilty of the crimes alleged. It's a review process because a number of them are sitting in jail having been found not guilty by 2 out of 10 jurors. Two people who sat on a jury panel and sat through a whole trial and decided that they were not guilty of the crime being alleged. And that is enough to go back and do a review. these bills would require that. I don't know why they're not moving, and I think it's probably because our legislature seems to move generally as a collective body far more swiftly when it comes to punishing juveniles and becoming harsher on people accused of crimes than doing anything to protect those who have been either exonerated of crimes or wrongfully incarcerated, or making sure that sentences that have been declared unconstitutional were fact based on guilt
Yeah.
instead of some other reason. But we gotta move these cases, Danielle. These two, at least one of them.
Yeah. Well, I pray that they start moving and we can certainly put pressure on the speaker and the Senate president to get these things into committee, because it's a disgrace that we would,
Chuck Owen said there could be as many, there could be quite a number of these 1,500 who are sitting in jail who are actually not guilty of the crime for which they were charged.
And Chris, don't you think that is, I mean, ultimately, if those people are killed at the hands of the government for crimes they didn't commit and the legislature did not act to review their cases, I mean, is it not that there's blood on the hands of those who had the opportunity to do something about it?
Absolutely. No question about it. And it's interesting that it's Chuck Owen, who is a staunch constitutional conservative Republican, who is bringing legislation to make sure that 1,500 inmates who were convicted of very serious crimes get review of their cases. I just think that's pretty powerful in and of itself.
It is, and it's refreshing because usually we only find that the Democrats are siding with us on matters of criminal justice, especially restitution. So it's good to see that the Constitution means something, the full Constitution means something to more people in the legislature than we
Absolutely.
might have thought.
It means a lot I know it means a lot to Chuck Owen personally
Yeah.
because I've talked to him about it, and I'm sure it means a lot to Senator McMath as well.
Yeah, I'm sure he wouldn't have brought the bill if he didn't care about it. All right, next up, and this is going to be the last bill, y'all, so we're almost there. House Bill 410. This is a bill that we have opposed, we have hated, we have raised a big stink about, and that's Lori Schlegel's bill that basically makes it illegal for citizen journalists to record conversations without the consent of someone who may be admitting to some ethical lapse or anything else. Chris, do you want to talk about where this is postured? Let me see. I'll tell everyone where it's postured. It's
House
scheduled
floor.
for the House floor. It was scheduled to be heard or voted on the House floor on April 7th, and it got returned to the calendar.
Yeah, and it's going to be going back to the floor. We sent an email last night to notable Republican legislators demanding an amendment to this bill. This is dual consent. By the way, Danielle, 38 states right now operate perfectly well under one-party consent. So we would be, if we pass this law requiring as a general rule both parties to a conversation to consent to recording, we would be an outlier. We would be in the minority.
Yeah.
But anyway, that's what the bill does. It requires as a general rule that both parties to an in-person conversation, which means face-to-face, have to consent to the recording. There are a number of exceptions. If you anticipate a crime or a civil or administrative proceeding or law enforcement, you can record, or first responders. There are a number of exceptions, but there is no omnibus, and there's no omnibus exception for exposing public corruption. And it's so interesting to me that that's the one exception that's not included in the bill. So we're demanding this amendment because I think it's extremely important. And here it is. The provisions of this section shall not apply to any person who in good faith records a communication based on a reasonable belief that the communication concerns public corruption, malfeasance in office, or a matter of significant public concern. Further, no public official shall be deemed to have a reasonable expectation of privacy in any communication related to their official duties or the conduct of public business, regardless of the location of the communication.
I like
That
that.
is the amendment that we're demanding go into this bill to protect investigative journalism and to prevent a chilling effect on individuals who act in good faith to expose corruption in our government. And I can tell you, this is going to be weighted very heavily on our scorecard, and any Republican who votes for this bill without this amendment in it, in our view, is facilitating the concealment of public corruption and chilling the people's right to transparency. It's extraordinarily important to us that this amendment be in this bill. The alternative, if they don't, is we're going to oppose it, and we're going to ask them to kill this bill.
Yeah. Yeah. Well, they need to kill this bill because it's not doing anything useful. I mean, I
Not
guess
doing
there may
anything
be some cases. I mean, there may be some cases where you want two-way consent, but I think that we should err on the side of freedom of speech.
No, and government transparency, Danielle, I could go down a long list of
Yeah.
corruption that has been exposed by citizen journalists, investigative journalists, by the use of the of recordings, and this is not going to be tolerated if they put this forward. Danielle, I don't know whether or not this is a reason for the bill. I'm not even sure if Laurie Schlegel ever thought about it, but
Well, she certainly heard about it whenever you testified in committee.
well, she certainly did. But the way we're phrasing is that if this amendment doesn't go into it, one of the unintended consequences, of course, unintended consequences of this bill would be to chill good faith investigative journalism, and we're not going to have it.
No, we're not going to have it. Well, that rounds us out for the day. Believe it or not, here we are a little over 2 hours. Thank you all for sticking with us. I know that this was a lot of information to take in. It's been a lot to for us to kind of jockey and keep hold of. But so y'all pray for us. We need all of the prayers and the support that we can get. We are. I'm feeling optimistic, Chris. I mean, I feel like today was a really good report. Last week we were so stinking mad about HB 7, but at the end of the day, we're also optimistic about that because we know that ultimately the Constitution has to stand.
Yes, indeed.
That's no excuse for bad legislation. It's no excuse for the voice of the people to be trampled on by legislators, but we do think that ultimately we will prevail in that fight as well. So just encourage everybody, stay informed, stay tuned in to us. We're here Tuesday, Wednesday, Thursday in some form, 8 a.m. Central. I've kept For the Love of Freedom at 10 a.m. Just because I have some guests that come on that prefer a later time zone because they're on the West Coast. But anyway, for the most part, you'll find us here at 8 a.m. You can find all of the updates for what's going on LeCag's Facebook page. Y'all are putting out stuff, spitting fire many days of the week, every day of the week, really, letting people
And
know
on
what's
X.
going on, and on X.
And on X.
So stay tuned there, and if you would consider supporting us because we need all the help we can get. It's not free for us to put this show on. It's not free for Chris to go down to the legislature. Obviously, there's trade-offs on our time for what we're doing. So please support the State of Freedom at join.freedomstate.us, or if you want to give a larger donation than our Warrior Circle donation, you can do that through the support page on freedomstate.us, and support LeCag. If the words will show up. I'm pressing the button, Chris. I swear I am. There we go. There we go. Support LeCag at lecag.org because Chris is doing great work at the legislature and Katie is tearing it up on all social media fronts. So just appreciate you both so much, and thank y'all for leading the way in this fight, and I think being a reliable voice that the people of this state can trust for telling the truth about what's happening.
Thank you, Danielle, and it's exciting to continue to build our reach, both with LeCag and the State of Freedom. I mean, we are We are expanding quickly and broadly. And I think that people are listening to us and they trust what we say. And it's trust that we've earned. And you know, as we continue to build, I know our influence will continue to grow for good. Because both LeCag and the State of Freedom truly are committed to being the voice of the people and the Constitution, and that is it. And we can't be bought and will never be bought. And I think that is why we are able to say what we say in an uncensored and unapologetic way. And we're going to continue to do that. So what a pleasure. What a pleasure. Who knew that 2 hours and 5 minutes could go by so quickly?
So quickly. We will see y'all back here Tuesday morning at 8 o'clock, bright and shining. Get your coffee for that. And in the meantime, stay in touch on social media. We love you guys.
Inveighing we shall go. God bless you, Danielle.
God bless you.
Go. It's just unbelievable. Whether it's the flame-grilled carne asada or a signature mango margarita. I had one of those too. They're serving up a literal feast of freedom at Calle Fuego. It's just extraordinary. I love the owners, Andres and Jose. They run such a great restaurant. The service is extraordinary. The atmosphere is great. So if you're in Pineville in the Alexandria area or passing through, or if you live there, go to Calle Fuego and tell them the State of Freedom sent you. Blanco Brothers has been in business in Louisiana for about 30 years now. I have personal experience with this company, and I know others who have as well. If you have a business or a home and you've got roofing, gutter, sheet metal issues at all, one number you need to know, and that's Blanco Brothers Construction. He will treat you right financially, and he will take very good care of you with regard to the quality of the service that he provides. I cannot recommend Blanco Brothers Construction more highly enough. Memorize the number 225-226-4222. Blanco Brothers Construction, the very best in the business.
Thanks for joining us today on the State of Freedom. Any follow-up actions, resources, and links to our sponsors will be in the show notes. All calls to action can be taken at lacag.org. That's LACAG.org.
To learn more about our work, become a monthly subscriber, supporter, or advertiser at freedomstate.us. The State of Freedom, the #1 conservative podcast in Louisiana.